Did you? Yep, there we go. All right. How's everyone doing today? Today is Monday, December 8th, 2025. The time is now 6:02, and I will bring to order the task force to study the fiduciary adjudication in Maryland. In our agenda for today, we're going to discuss the draft preliminary progress report and extension letter. Then we'll go on and vote on a preliminary report and extension letter with any amendments proposed from task force members. We'll vote on any other potential proposals for recommendation, and then we will conclude the meeting. And so as we move forward, I'm going to have Holly and Joe kind of walk through some of the preliminary things in the progress report. Holly?
Yep. Joe, do you want to bring it up just so we can show it? And Senator, I'm going to pass it on to John, lastly with MSBA, and Senator West and Kelly with MSBA, because this preliminary report letter incorporated their proposal, which is essentially just saying that we are going to continue our work as the task force into the spring months. The task force officially terminates on June 30th, 2026. So we are essentially going to continue. And if John or Senator West wants to take over at this point, again, we just took their proposal and incorporated it into the progress report letter, which you see in front of you. And then we added in some materials at the back end just to show what our meetings were this far.
Yep, sounds good.
Okay.
John?
Thank you, Mr. Chair, members of the task force. Sorry, I'm on the wrong page. There I am. At the conclusion of our meeting last week, there seemed to be a consensus that we were not ready to make any big concrete recommendations, so that we would issue a preliminary report to meet our statutory requirement of reporting by the end of the year, and then continue our work into 2026. And over the course of last week, there were a number of discussions going on, and they produced the proposal you have in front of you. There it is. Okay. So basically, the idea is that we would continue our work during the legislative session. People would work on their own or in groups that they form themselves to research as they are able, conduct additional research, gather additional information, and hopefully develop some concrete proposals that can be then presented in writing the day after tax day. And then at that point, Chair Charles will work through those proposals, figure out how much additional time we need in conjunction with staff, and schedule meetings accordingly. And then hopefully we'll be able to engage in some of the big substantive discussions that we really haven't gotten into so far, as we've been gathering information over the past 7 weeks. So that's the schedule part. To try to focus that work, we propose 3 goals for the proposals coming forward, and these are, if possible, but hopefully we can aim toward them. Assuring that all judges hearing fiduciary matters are Maryland lawyers in good standing. Providing that in each jurisdiction there's a one-stop shop court for all fiduciary matters, and that each jurisdiction's arrangements be the same, taking account, of course, for geographical differences and demographic differences in terms of population and case count and things like that. But to the extent possible, each person walking into a courtroom should have the same experience no matter where they are in Maryland. And that into that latter point goes adequate staffing, both in terms of judges and in terms of support staff. Um, and then making sure that all judges are adequately trained, both as judges and as and in fiduciary matters. And then any other proposals or topics that people think are appropriate and are approved by the task force. We did not propose at this stage a statutory extension of the task force, but as I believe is mentioned, or it was mentioned in one of the emails, we're certainly open to that if the legislative members think that is desirable and or feasible. So those are our proposals. Holly, do you want to cover the last couple items there, and then Holly or Joe? And
Okay.
Joe, I'll let you take over that part if you
Yeah.
want.
Okay, we added the two things that we had consensus on during our time together in these last 7 weeks. And the two things are that we decided the first meeting, that you decided the first meeting, is what fiduciary means with respect to fiduciary matters, which is a broad definition beyond Title 15 in the Estates and Trusts article. So we have that there, number one. And then number two, you voted a couple weeks ago on the data, the workload data, the blue chart, which we have attached here. This chart that we agree, you voted a consensus on that. So we just wanted to note those two items of consensus. And that's the end of the report.
Yeah. Well, and the rest of the report, Joe, if you just want to
Yes.
show, we just have membership,
Yep.
which is just who's on the task force as staffers. And then we also included the charges of the task force. You see that on page 5. And that's from chapter 220 of 2025. So that's directly from the bill. And then on the next page, this is just a breakdown, very brief, of our meetings, and then directs people back to the webpage. But this just breaks down each meeting, what we talked about. And then again, the final page is just that chart that Joe just mentioned.
Okay, that's the report, preliminary report.
Since I was one of the proposers of this report, I wasn't aware at the time we proposed this that a couple members of the task force were going to submit what has been titled Task Force to Study Fiduciary Adjudication of Maryland, list of additional proposals for voting to be incorporated into the draft preliminary report. I think we could do that, and in doing that, we could achieve consensus on this report if we simply, on the second page of the report, as a part of Part 2D, which currently says addressing such other topics as may be proposed by members and approved by a majority vote of the task force, we could add one sentence there and saying, among such other topics that have already been proposed are the following, and then simply incorporate items 1, 2, and 3 from the list of additional proposals. That way I think we have what we've included in this report, what everybody wants. And we're listing a number of subjects to be discussed after April 16th, which is, that was a date chosen because it's after the end of the legislative session. 4 members of the task force are legislators. We're going to be really busy, especially as we approach April. I think 13th is the end of the session. So the 16th of April was chosen to be after the session's over, when the 4 legislators are going to be able to take a deep breath and then come up for air. So if we were to add those 3 other proposals in here as things to be discussed, I'm hoping we could all agree that this is a consensus product and we could vote for it.
Mr. Chair.
Yes, go ahead, Delegate Kaufman.
Senator West is one of my favorite colleagues, and I just am so fond of him, so let me preface it this way. But I just have to be honest. I'm an honest guy, and um, I'm in favor of meeting in the spring if other people think it's um, um, useful, but I think it may be fruitless because I'm just going to be honest and say that you have done your level best and you've done a great job chairing this committee. But one of the most disheartening things for me, Mr. Chair, has been um, I think we've wasted a lot of time with the constant um, barbs back and forth and sniping between the registers of wills and the orphans court judges, and I believe both parties, have some culpability there. And so I'm just, I expected some disagreements, but I would have expected more civil disagreements. So I'm just not sure. If we meet again in April, that we won't just be watching people trade barbs all over again. And if people want to meet, that's fine. I just wanted to put that out there that I think the tenor has been disappointing, and I'm not sure that's going to change in the spring.
I appreciate that, Delegate Kaufman. It's definitely we knew we were going to have that coming into the meeting. It was some of the preliminary discussions as we were prepared. We knew it was going to be hot on both sides. So, but to your point, I agree. If we're going to meet again and the same sentiment remains where we have arguments on both sides that can't be civil, I don't know if it's going to help us get anywhere closer and faster if we're going to continue with the same measure. So if you don't have anything else to add, Delegate Kaufman, I got
I do have one more thing, if I could, and
okay.
this is actually just a question. I thought, and admittedly, it's just a crazy time of year. I did have to leave, but I thought one thing that there was consensus on is that um, all judges need to be attorneys. And so, am I missing something, or is that no longer a
No,
point of consensus?
that we did not come to a consensus on that because just every jurisdiction is different. And when we looked at one of the reports, it showed us that some jurisdictions, some of the smaller jurisdictions, and a lot of them actually across the state have non-attorney judges. And so it's only a handful that actually have attorney judges. And so when you looked at the education across the board, the impact that will have on that jurisdiction would possibly put us in a position to have to change the entire structure of the orphans court if we did that. And so we have to be cognizant, and we'll that would have to be part of the conversation when we move forward if we move to meet and in the spring. You good to go, Delegate Kaufman?
Yes, sir. Thank you for your indulgence.
All right, thank you, sir. Mr. Lastly.
Thank you, Mr. Chairman. If I may, I'm going to respond to Delegate Kaufman's comments first, and then address Senator West's proposal. Delegate Kaufman, I think, despite the obvious interpersonal things that have been going on that you've identified, I think we're actually closer to consensus on practical issues than it may at first appear. And I think if we bring good faith proposals forward in the spring, we've got a legitimate shot at coming up with agreement, as long as people come in with an open mind and willingness to work with each other. So that's my opinion there. Senator West, I think that these proposals in the additional proposal document fall into the specific types of policy prescriptions that are really covered by the larger strategic goals in the proposal that we've put forward. And so I would say absolutely these suggestions should be considered as part of by everybody moving forward. And if we can find a way to incorporate them without actually agreeing to them, I'm fine with that, but I mean, I personally don't agree with all of these. But I'm happy to have the conversations about them. So I'd be open to, if you'd be willing to amend, I don't know if you made a motion, but if you'd be willing to amend your idea to say, among the things people ought to think about in looking at the goals are these three things, then then I think, that would be the way to proceed. But if we're going to say we agree to these things as being goals, I have a more problem with that.
Oh, no, I wasn't suggesting that at all. I agree with your formulation, which is we should add these three additional items to the list of things that we will consider in the spring.
Okay, thanks.
All right. Anything else, Mr. Lastly?
That's it for me. Thank you, Mr. Chair.
Okay, Judge Groves.
Sorry, I just noted I was still muted. Just to comment, thank you, Mr. Chair. With respect to the attachment with the numbers, I think it's page 9, there appears to be a mistake, and I don't know. I don't know what the numbers for Allegheny County is, but this reflects that Allegheny County has the highest number of estates in the state. And I can't imagine that Allegheny County has more than any other jurisdiction, but I could be wrong. So I just wanted to point that out, that there was some question regarding the number of estates activities for Allegheny County, which is the highest number in the state.
Okay.
I'll double check that. I'll double check that right now, Judge Groves, and report back.
Okay,
It might have been a typo.
thank you.
All right. Is that it, Judge Groves?
As far as that's concerned, and I would agree with John's comments regarding not adding those proposals into the body of what's going to be submitted from this task force.
Okay.
Thank you.
All right. Thank you. Ms. Rowe.
Thank you, Mr. Chairman. I have a question. This is addressed to the delegation. So if this does go forward, and I looked at all the meetings of the last task force, and there were recommendations that have been made. Why didn't this go forward? I know you weren't, I don't know if you were on that task force or not. What was the reason that this never went, or that there was not a bill for these recommendations to go forward?
From you, are you asking from the previous?
Yes,
task?
sir. Yes, sir.
Yeah, this isn't my subject matter expertise, so I never would have put a bill in on any of this. So I will go to our good friend, Senator West, who has been the man, the myth, and the legend behind all bills dealing with trust, states, and all fiduciary matters. So, Senator West, is there a reason or any rationale behind why you did not put any bills in to address this?
So the last task force met and had a couple of recommendations. I chose the one I thought was the most important, and I introduced a bill which was ultimately passed to adopt that, which was to enable lawyers who ran for and got elected to the circuit court, to the orphans court, to continue to practice law. In the old statute, in most of the counties, if you're a lawyer and you got elected to the orphans court, you couldn't practice law for 4 years. And of course, this discouraged good attorneys from running for the orphans court. So I thought that was the most important, and we got that done. And the other pieces could have been introduced in subsequent years as legislation, but this particular, the legislation creating this past task force took precedence. So we decided to go forward with this task force instead.
Okay, thank you. Yeah, I was curious because I guess the little frustration is I'm feeling is we have the task force, and I think it's great that we're going to go. I think we should go forward because I believe the last task force just ended in December. Correct me if I'm wrong, but I do believe that if we really get down to work, and I think if we continue with the task force, is we need more discussion instead. We've done a lot of research, a lot of numbers, actual discussion, maybe a step at a time so that maybe we can move forward then with this. And then the last thing I want to say is that I would highly recommend that we add the 3 additional proposals. Thank you.
All right, thank you, Ms. Roll. And I will say, we should definitely take a look at the recommendations that came from the last task force and map them against what we have discussed in this meeting, you know, amongst the meetings that we have had. And it will help us. And I know that when Senator West leaves us and chooses not to return to the Senate, I think he's trying to drop this on my lap and make me the guy who is the one who then focuses in on estates and trusts and all fiduciary matters. And so we'll have some of those conversations in committee, Senator West. I know we may be having we'll be going into session in a month or so. So we'll talk more in detail on those things. All right. If you don't have anything else, Ms. Roll, I'm going to go to Mr. McFarland.
Yeah, thank you, Mr. Chairman. I have a couple of comments. First off, I want to I guess, thank Senator West for trying to find a way forward where we can find some agreement. Second, with Delegate Kaufman, I just like you have a lot of respect for Senator West, I have a lot of respect for you. I can't say that I completely agree with the both siding of the disagreements that we've been having. But it's unfortunate that things that are so, to me, so very crystal clear and reality are disputed by the judges. And I do believe I'm actually kind of ambivalent about continuing this work into the spring, because I can tell you right now, I mean, whatever else, you know, anything that me or my colleague from Frederick County produce that doesn't reflect positively on the judges is going to be the result. I mean, we're going to have another argument about data. It's going to be, I don't know where this came from. And so I don't know whether anything more can be gained. Personally, I think we've heard enough. Personally, I think we've heard enough to make substantive recommendations to the legislature and let them make some decisions. So, you know, and I guess I've got a question for Mr. Lastly and a statement for Judge Groves. One of the things that we do, and just to clarify what the duties of the registers are, is that we send our records to archives periodically. This past year, Allegheny County had a significant number of estates that were digitized and permanently archived. It was a long-standing project. That's why that number is so high. It's high for this year. Next year, it will go back to what you might assume it is. So perfectly reasonable explanation. It's not an error. That is how many estates were touched last year. Okay. Now, my question for Mr. Lastly is, what you are proposing in this preliminary report, would there be any substantive legislation that would have any impact on fiduciary adjudication filed in the 2026 legislative session that could have an impact on the system that we have before 2030 at the earliest?
I don't know if
Filed
that's
in,
for Mr. Lastly or not, because the legislature would have to submit the bill. And so that would be more inclined to a conversation between all of us, Senator West and Delegate Kaufman and Delegate Bartlett, if that's something that any of us would like to move forward. But I do have a quick question about the data for Allegheny County that you mentioned. Now, when you guys were digitizing all of that information, is this from one fiscal year, or is this from multiple fiscal years when you finally were able to digitize all of these documents?
It was within 1 year.
This is all within 1 year?
Yes.
Okay. Okay. But yeah, in terms of, as you heard Senator West mention, and he made it clear, there were other recommendations that came from the previous task force, and he moved forward with only one piece of the recommendation. I guess I did not look at any videos from the previous task force, but I don't know if it was a lot of back and forth, a lot of controversy as much as it's been with this. I will say this, Mr. McFarland. I know that one of the things that for me, that where I agree with Delegate Kaufman in terms of the back and forth, is that this task force, though it's the law that we passed, it's allowed for us to just focus on one group but have another group that can make recommendations on another, versus the two being able to make recommendations on each. And I think it would have been a lot fairer to see that. And then I think that would have made you guys come together a lot more differently if both parties were going to be impacted based off of recommendations. And so, but obviously, that's something we can address in the legislature if we choose to in the next session starting in January. But that's a conversation that my colleagues and we will have if that's something that's feasible for any of us to put forward.
Okay, and the reason, I'll just say briefly, the reason I asked that question, that if I'll just say, given everything that we've heard during the last 7 weeks, if I do not have some kind of assurance that the people of Maryland, when they walk into a courtroom through the end of 2030, can know that they are going before a lawyer judge, I can't in good conscience agree with this letter. The idea that that literally 5 years from now, people could still be walking into courtrooms and have someone who's 18 years old and a high school dropout interpreting their dad's or their mom's will, I can't agree with that. I'm sorry.
And
That's all I have.
And Mr. McFarland, that is quite fair. That is the beauty of every person having a vote on this task force. We could all agree or disagree or find things that we agree on, but we truly appreciate all of your commitment to the work and the future commitment you have to the work as we address this. But thank you for your comments. I'm gonna see Delegate Kaufman. You still had your hand up again. I don't know if this is a holdover from before.
No, it's something new, Mr. Chair, but I'll be very brief. Just Mr. Lasley, I think in terms of the work that is done, you're a lawyer, not me. The work that is done while we're in legislative session, I think we have to be very, very careful to make sure we don't run afoul of the Open Meeting Act. So I'm not saying don't meet. We just need to be very careful about that.
Understood, Delegate Kaufman. Agree 100%.
All right. Is that it, Delegate Kaufman?
Yes, that was it.
All right, Judge Fisher.
Thank you, Mr. Chair. And I do share some of this. It feels a little bit more like Judge Groves and I felt like we've had to defend things because there are courts, and a lot of the people in this task force, unfortunately, haven't had the actual day-to-day in-person experiences with the court. So I think that we are protective of this court because we love this court. I think that the most disservice we could do as members of this task force is to stop the work before the work is finished. I think when we heard from the smaller jurisdictions and the lay judges and trying to figure out and navigate a system that best suits everyone in Maryland and make sure the needs of every citizen in Maryland gets met is not a simple fix. This is why we've ended up in this system that we have now. And so I think putting in the work, I know I've spoken to people in the Bar Association before. Obviously, Judge Groves and I've spoken, and we're trying to reach out to more of our colleagues. I think that there are reasonable and productive conversations that can be had. I think what John put forward in this letter, and Kelly, is a really good start to opening up the options and the parameters for us to do additional work and to come back in the end of April with some real solutions. Senator West did put forth another bill because I have testified on the nonpartisan bill. I think Senator West put forth, and I think I've testified on at least 3 or 4 different years, the nonpartisan elections, which I will say passed unanimously through the Senate, but never got out of Judiciary in the House. So there was a second recommendation from the original task force that was put forward multiple times with no success as of yet. I'd love to see that as part of any recommendation. I think it will be. With respect to the additional proposals, the information concerning the first one, amend the Maryland rules to allow public inspection of educational materials, I don't think is appropriate. The judiciary has already determined that it could only be released under very certain specific circumstances. I don't think that we need that to move forward. I think we have an idea about what sorts of requirements, I think John had put in the letter, mandating improved education and training for all judges hearing fiduciary matters. I don't think we need to go backwards again in this task force. I think we've done plenty of going backwards and looking at different things. And I think what we need is to be moving forward. I think amending the Maryland rules to allow inspection of judges' educational data, which is privileged, is extremely inappropriate. And I would object to that being included specifically in any sort of recommendation, even a preliminary one. And then striking all the testimony relating to the training in orphans court judges. I'm not sure how that even gels with one, so that no member may make any future statement on that subject for the remainder of the future work of the task force. So why are we on one hand trying to release the judge's education data, and in the second part, striking all testimony and somehow prohibiting anyone from ever mentioning training again? So I strongly disagree that either of those should specifically be included in, and I believe it's up to the judiciary and the judicial college to determine how best to release, if at all, any judicial education records for circuit court judges, orphans court judges, or any other judges in Maryland. And with respect to the third proposal, it's just to basically make it Harford, Howard, and Montgomery counties. I think John's 2B that requests, providing in each jurisdiction a single court, preferably a specialty court or division, encompasses that being one of the options. So I don't think we need, I could say I want the orphans court judges to stay exactly the same, or we could say we want to have no panels, or we could say we want no de novo hearings. Those are specific options that are all available under 2B. And I would hope when we come back at the end of April that we can have fleshed out some of those to see what would be the best option moving forward, so we could have uniformity in the state. I think including that one specific proposal without other proposals that other people might have would not be in this task force's best interest. I think leaving it general and open to interpretation so that we can all come up with proposals that would create that uniformity and work in the small and the big jurisdictions. We heard, I think it was Queen Anne's County, the clerk, who said they can't absorb it. So I think that there's more information that we need to glean, but in a forward positive progress. None of this let's go back and forth on old numbers. We all have an idea about what the workload is, the number of estates that are opened in each jurisdiction. Let's move forward with that information, and we can each reach out to individual jurisdictions and see what their needs might be, so that we can definitely take care of both the small, the big, and the medium jurisdictions in Maryland. So I would recommend not adding any of those additional proposals, but I am in favor of John and Kelly's preliminary report in the way that it's drafted.
All right, thanks, Judge Fisher. I will say this about the training. I was a little disheartened when I saw the amount of folks who did not finish the training that they were supposed to complete. The actual numbers in comparison to the circuit court. And
excuse me, Mr. Chair.
Yes.
We're going into confidentiality zone.
Oh, okay.
We can only talk about it if only the members that have signed the agreement, and I don't think it's up. Well, I'll let Holly explain.
Yeah,
No,
Holly,
that's right, Delegate Bartlett. We have to be very careful here. It is privileged and confidential information. Thank you. But yeah, we
thank you for that, Delegate Bartlett. Keep me tight. Thank you. I appreciate that. But I what I will say is, though, I just think we definitely need some work. We have to figure out the best pathway forward around the education piece of things. And so I would ask that everybody sign the confidentiality so that we can have a more robust conversation around it. Mr. Lashley.
Thank you, Mr. Chair. So I just wanted to quickly address the question that Mr. McFarland raised. I believe we wouldn't be looking at 2030. I believe we would be looking at 2028, because I think, and please correct me if I'm wrong, somebody, but I think constitutional amendments can be considered at any general at any general election. In addition to that, anything that doesn't go to a constitutional issue can of course be enacted, could of course be enacted as soon as 2027 or even this year, depending on where things stand, but most likely 2027, to address other things. So for example, if we come up with a solution on education and training, that could easily be enacted in 2027. Because it doesn't involve constitutional issues. So I think we're not looking at 2030, but 2028. But please correct me if I'm wrong, anybody on here. That I yield, Mr. Chair.
Thank you, Mr. Lastly. Mr. McFarland?
Yeah, so John, to your point, what I'm saying is, yes, of course, the legislature could pass something in the interim. What I'm saying is that they could pass a constitutional amendment next year for 2028, or they could do it in 2027 or 2028. But that we would continue to have like barring some kind of legislation passing this coming session, we will continue to have the status quo orphans court system through the end of 2030. That's my concern. I strongly object to that. I think the people of Maryland deserve so much better than that. I mean, you yourself and others here have said when people walk into a courtroom, they expect the person there before to be a lawyer, to be experienced, to be vetted. And I cannot in good conscience co-sign on anything that does not guarantee that the public isn't subjected to that for another 5 years. I feel like waiting half a decade to do something that we've all, to some extent, acknowledged needs to be done. I simply can't go along with that. And as far as the education and training of judges and amending the Maryland rules, I understand, obviously, that the rules say that that information is confidential. That's why I'm proposing that we at least have a discussion, per Senator West's statement, in the spring about whether we want to adopt that proposal, that those rules be loosened to allow the public to know whether judges are doing their job. I don't think, the fact that we have opposition to even talking about that, to me, speaks volumes that we have to have that discussion. You don't even want to, we have a judge here who doesn't even want to talk about it, much less adopt that as a recommendation. There is a Supreme Court order that says that judges have to go through a new judge orientation and 15 hours of continuing education every year. And if it is a judge's position that the public does not have a right to know if a judge is doing their job and complying with the law, that's insane. I mean, that's absolutely appalling. If you think the public doesn't have a right to know that, I think that is a basic matter of trust in government at a time, frankly, when trust in government is at an all-time low. So, I think that that's, something I would like to see us adopt tonight, but if we don't, at least have it as something that we consider down the road, along with the other litany of proposals. Thank you.
Thank you, Mr. McFarland. Senator West?
Thank you, Mr. Chair. Two things with respect to the timing of the constitutional amendment. If we pass a bill if we make recommendations later this summer, and in the 2027 session, a proposed constitutional amendment is adopted by the General Assembly, it'll be on the ballot in 2028. And if adopted by the voters in the fall of 2028, it will become law. So we're not waiting until 2030. Secondly, because there's been some confusion, let me read specifically my recommended amendment to this the proposed letter. It said on page 2 in subpart 2D, would simply add the following sentence. Among the matters which have been proposed by members and which the task force will consider are, and then incorporate the 3 matters contained in the alternate proposal. All it says is that those matters have been proposed by members and the task force will consider them. Doesn't adopt them. It merely says we're going to discuss them. Thanks.
Thank you, Senator West. Judge Fisher?
Just briefly, I mean, I'm just going to not even respond to some of the rest of it. What I understand from the judiciary is that there's confidential records, there's confident personnel records with respect to every other profession. I have gone to all of my training. I've always gone to all of my training. I am not here to speak for my other colleagues. I know that the number of hours recently changed from 12 to 15. I know there were some scheduling issues this year. Without going into any more of it, I'm not sure without polling people what's going on, but it seems like this past year was maybe not reflective of the prior years. But that's all I'm going to say because it is confidential. But the second recommendation is strike all testimony related to the training education of orphans court judges, that none of the testimony may be considered as part of our voting session Monday or any other future work. So I don't feel like that one can just be flat incorporated into a later recommendation, because the suggestion is we vote that none of it may be considered as part of our voting session today, which I don't really understand because it was just brought up, but it's to strike all testimony from this task force in the last 7 or 8 weeks, however long we've been meeting. So I don't really see how that's a forward recommendation towards determining how to best handle fiduciary adjudication in Maryland. And secondly, I just think that this is a really important thing. If we're going to substantively change this court, which I'm not saying that I'm opposed to or in favor of at this point, we need to do the work of looking forward and not just make quick recommendations just so we can make quick legislative changes without really considering, if you say you wanted to make everyone attorney judges in this legislative session, what happens in the counties like Somerset or Garrett where there's not enough attorneys? Then we're not going to be able to seat a court. All of those recommendations are caught up in all of the rest of them, and they're also entangled together, that really I'd like us to just be able to come to one consensus and not feel like we have to rush to make a decision that might not be in the best interest of the courts. We haven't heard a single person from one of those small jurisdictions come to this task force and complain that they're unhappy. I don't think waiting a couple more years to make sure we do this correctly, which is what I consider our job, is that much of a burden. I think the burden would be making recommendations that don't actually work.
Judge Fisher, I do believe you when we say we should definitely have more people come speak to this. It's a lot of, I think we learned a lot more when we had some of the smaller jurisdictions, when they came out and spoke about they only got one judge, and some folks don't have a courtroom, let alone space to do certain things. So I think we really need to get a lot more of the lay judges to participate in this conversation, since they would be impacted. A lot more of the smaller jurisdictions, maybe some of their county executives or county commissioners and their clerk folks that could speak to some of the issues that they may be seeing as elected officials within those smaller jurisdictions. But Mr. McFarland, I see you have your hand raised, and then Delegate Bartlett, it'll be on to you.
Okay, just very briefly, on the second proposed recommendation, when it comes to the public record that has been offered related to the education and training of judges, it is my belief that there have been substantial misrepresentations made to this body and to the public. And that is why I am proposing to have those statements and documents struck from the record, because I believe that they are misleading. And over the next 4.5 months, we may find a way to explain more thoroughly why they were so misleading. And I'll just come back to, as far as making some kind of change in the interim, I don't see how, given everything that we've talked about with age requirements, with retirement requirements, with vetting requirements, I don't see how we could conceivably, to me, it looks like we've got the status quo or some kind of conversion to the circuit courts. And whatever that looks like, I'm not exactly sure. But, we've heard over and over and over again, I wish if I had a nickel for every time I've heard, we'll need a new judge in every county because we have so much work. Well, Howard County is the 7th largest county in the state. we were able to absorb all of our probate matters without a new judge and just one assistant. And I think, when we heard from our circuit court judges, not one of them said that they were overburdened by the amount of work that this required of them. Not one. It's actually the contrast, which hearing from some of the lay judges and attorney judges, it seems like you are perpetually overwhelmed. So I would love to hear from some more folks who've had experience in the circuit court jurisdictions, because an awful lot of the problems we've talked about, interference with the registrar's offices, the 3-judge panel problems, all of those things go away by having that system. And I don't know why we wouldn't want to go ahead and move in that direction next year, and then flesh out in the out years, take the time to figure out exactly what the expanded jurisdiction would look like. That to me is something that makes a lot more sense. You guarantee that starting December of next year, every member of the public goes before a trained, vetted lawyer judge when they're dealing with their loved one's estate. Thank you.
All right. Thank you, sir. Delegate Bartlett.
Thank you, Mr. Chair. I move to accept the proposed letter that was drafted and that was presented to us.
I second it.
It's been moved and properly second that we accept the letter. We're going to go, because I know we don't have everyone who would agree with this. Instead of signifying by aye, we'll call for a roll call vote.
Okay, I'm prepared for that. The matter before the task force is adopting the preliminary report and extension request that's on the screen dated December 8th, 2025.
Just to be clear, that's as it's drafted currently right now in front of you, not with any changes or proposed amendments.
That's
So you're taking
correct.
roll.
That's my motion.
Thank you.
Okay. Judge Groves.
Aye.
Judge Groves, aye. Judge Fisher.
Aye.
Judge Fisher, aye. Mr. Lastly.
Aye.
Mr. Lastly, aye. Ms. Pederati.
Aye.
Ms. Pederati, aye. Mr. McFarland.
No.
Mr. McFarland, no. Ms. Raleigh.
No.
Ms. Raleigh, no. Ms. Mitchell.
Aye.
Ms. Mitchell, aye. Delegate Bartlett.
Aye.
Delegate Bartlett, aye. Delegate Kaufman.
Aye.
Delegate Kaufman, aye. Senator West.
Looks like the ayes have it. I'll go with an aye.
Aye. Senator Charles, the chair.
Aye.
Aye. The motion carries 9-2.
All right. I saw we had some other hands raised. I know you guys wanted to may talk a little bit more in detail, but we just voted on the preliminary report. Did you guys want to have any close out and say anything prior to Senator West? Senator West, you're muted.
Yes, so we didn't adopt my amendment to the letter, but the letter as drafted says, again, in section 2D, addressing such other topics as may be proposed by members, and et cetera. So this doesn't preclude any member of this task force from coming back in April and proposing whatever you want to propose. So I hope we can all leave this evening hopeful that in the spring, we'll take a look at a litany of proposals and we'll sort through them and discuss them and come up with good decisions about which ones we're going to adopt. Thanks.
All right, Mr. Lastly.
Thank you, Mr. Chair, and I want to thank you in particular for bringing us this far down the road. Really appreciate your leadership and appreciate the efforts of everybody on here. I know it's not always pleasant to go through this, but I really do believe we've made progress, and I do see hope for the future, and I hope everybody can move forward in that spirit.
And thank you, Mr. Lastly. And I just want to thank everybody on this task force. Every Monday, you guys have put it all on the table and brought all the issues here. And we may not all agree, on where we should be, but this is getting us a couple of steps forward to where we should be. And we'll address this later on in April. So if you guys want to push a bill, all your legislators are in the process right now of drafting legislation. Anyone who wants to make any recommendations, it just won't have the backing of this task force, but you can go directly to any legislator. And that's for the public that's listening as well. If anyone has any recommendations, reach out to your Maryland state delegate that represents your district or to your state senator and ask that they draft a bill that makes a change that you see fitting for this particular type of work. And with that being said, and not having any other questions presented at this time and no other hands raised, I'm going. Mr. McFarland?
Yeah, Mr. Chairman, I would just be, I think you already just said this, but if I could, I just really want to say thank you to Holly and Joe and Jesus for doing an incredible job supporting all of this work. I know there's been a lot of back and forth, and none of this happens easily. So I just want to give the three of them a shout out for their very, very hard work. When I finished law school, I actually thought about applying to DLS for a job. I decided to run for register instead. But in any event, I just want to say thank you to all of you.
Yes. Thank you.
Thank you very much.
Thank you guys so much. With that being said, and not having any other hands raised or any other comments to be made, the time is now 6:53. I'm going to adjourn the meeting and we will move forward. Thank you guys so much. And have
Thank
a
you,
happy.
Mr. Chairman.
Thank you. Happy holidays, everybody.
Thank you. Happy holidays. Have a great session.